Now, let us ponder to the question, is a public official or employee be imprisoned if he or she made a false narration in his personal data sheet or PDS, simply by answering no to the question on whether he has any pending criminal case where in truth and in fact he actually had it? So, the answer to that question is yes, he or she could be imprisoned for making a false narration in his or her personal data sheet, or also known as the PDS. And it was elucidated in the case of Sevilla versus People, GR number 194390, August 13, 2004. Alright, so to discuss further, in the case of Sevilla versus People, GR number 194390, August 13, 2014. So, Venancio Sevilla, a newly elected councilor of Malabon City, was charged with the crime of falsification of public document when he allegedly stated in his personal data sheet, an official document, that he had no pending criminal case, when in fact he is accused in a criminal case for assault upon an agent of a person in authority, thereby perverting the truth. In his defense, he alleged that he merely signed the prepared PDS, which he ordered copied from his old PDS. This prepared PDS was brought to his home by his secretary, and he still had no office net. After the trial, the Sandigan Bayan found him liable for the crime of falsification of public document through reckless imprudence. And so, the issue in this case is whether or not Sevilla can be held liable for the crime of falsification of public document through reckless imprudence. So finally, the ruling in this case, according to Supreme Court, is yes, Sevilla is liable. However, the proper designation of the felony should be reckless imprudence resulting to falsification of public documents and not falsification of public documents through reckless imprudence. Moreover, the Sandigan Bayan designation of falsification of public document through reckless imprudence implies that reckless imprudence is not a crime in itself, but simply a modality of committing it. This is incorrect according to Supreme Court. Quasi-offenses under Article 365 are distinct crimes and not a mere modality in commission of the crime. To stress, reckless imprudence resulting to falsification of public documents is an offense that is necessarily included in the willful act of falsification of public documents, the latter being the greater offense. As such, he can be convicted of reckless imprudence resulting to falsification of public documents, notwithstanding that the information only charged the willful act of falsification of public documents. According to Supreme Court, the criminal negligence in our revised penal code is treated as a mere quasi-offense and dealt with separately from willful offenses. It is not a mere question of classification or terminology. In intentional crimes, the act itself is punished. In negligence or imprudence, what is principally penalized is the mental attitude or condition behind the act. The dangerous recklessness, lack of foresight, lack of care, the imprudentia punibus. And the imposable penalty under Article 365 of the Revised Penal Code, reckless imprudence resulting in falsification of public document is punishable by arresto mayor in its maximum period to correctional in its medium period. In this case, taking into the account the pertinent provisions of indeterminate sentence law. The Sandigan Bayan correctly imposed upon Sevilla the penalty of 4 months of arresto mayor as minimum to 2 years to 10 months and 21 days of prison correctional as maximum. So that was the ruling of the Supreme Court in the case of Sevilla versus People. Ultimately, the doctrine in the case of Sevilla versus People is that in intentional crimes, the act itself is punished, while in negligence or imprudence, what is principally penalized is the mental attitude or condition behind the act. The dangerous recklessness, the lack of care or foresight, the imprudentia punable. So that would be all. Thank you.